Thank you. I'm happy to be here on such a typically beautiful New York February day. I speak not as a Google employee, but as a copyright maven. So I shan't address the Google Book Search project or the hearing last week on it, although I recognize it's probably a topic of great interest to everyone, and it's a topic of great interest to me as well. But I'm not a Google spokesperson, and if I was a Google spokesperson, I wouldn't be permitted to be giving this talk. So I hope at the end, at least some of you will say the glass was at least half full. For 10 of you, my thoughtful publisher, Oxford University Press, put a slip somewhere under your chair saying that there's a free copy of Moral Panics and Copyright Laws, which will be handed out promptly at 10:15 in the Plymouth Royale room, which is somewhere over there. Now, my topic, I believe, is law is not a solution to business problems, and it may seem odd for a lawyer to think that law isn't a solution to every problem, but it isn't, and it should be common sense that it's not. Law should only be used to solve problems that are uniquely legal. If there are non-legal ways to solve problems, then we should use those. The last thing we should want, I think, is for lawyers, courts, and Congress to get involved in issues that law wasn't intended to solve. No good and lots of bad can occur when that happens. One of the things that occurs when it does happen, I think, is that we lose respect for the legal system when it's utilized to solve what aren't legal problems, but are instead business problems. I would also say that even when there are legal issues, not a lot of people have a great deal of respect for how the legal system solves those problems. Dahlia Lithwick, who covers the United States Supreme Court for Slate, said in a recent interview, "The legal system might be the single worst place to seek closure, whatever closure means. Nobody ever feels whole or vindicated or truly heard." Now, last year I had an experience in my own family with this phenomenon. My wife is a former lawyer. She worked here in Manhattan for 4 years for 2 different federal judges. She got pregnant, thoughtfully at the end of her clerkships, for which her judges thanked her. And then she stayed home for about 4.5 years and decided she wanted to become a bakery cafe owner. So she got together with a friend of hers, and they opened this cafe as a joint proprietorship, and went along fine for a few years. But like most joint proprietorships, there was a falling out. My wife bought out her business partner, but afterwards there was stuff going on that she didn't like. So being a lawyer, she sued her former business partner in federal court, because we didn't really understand anything about the state courts. And there was a settlement. But, it didn't make any difference because the conduct continued and the court refused to get involved in it further. And so now my wife, who, grew up professionally working for these very courts, now feels rather bitter about them and that she would never go back to them regardless of what the problem is. Now, unfortunately, there have been too many in the copyright industries and some on the other side, too, who feel as if laws are the answer to all other problems, as if the more laws we have, or the stronger the copyright laws we have, the more fully their problems will be solved. There was a while back an executive at a network who said that piracy was the #1 problem for that network. And you have to ask yourself, really? Was piracy the problem, say, for the Jay Leno debacle? Was piracy the problem for overpaying for the Winter Olympics, for being 4th place in the ratings? People don't copy stuff that they don't watch. So, I would say, thank you, I would say that those aren't copyright problems at all. Those are market problems, and you can respond to them only in one way, by giving consumers what they want. Stronger copyright protection can never make consumers buy things they don't want to buy or watch shows they don't want to watch. The problem really, I think, is a fundamental one of a failure to innovate, a failure to put consumers first, and a fear of the market as a dynamic process. For too many, law has become an end in itself, right? It's become a crutch by which you preserve where you are now. This is especially true for incumbents of all stripes, and it's not limited to those in the copyright field. There's a belief that if you can succeed at passing yet another copyright law, if you send some 19 or 20-year-old kid to jail for 25 years, that somehow that's going to save your bottom line. It's just not true. It's not going to do it. It's not going to make more people go to the box office. It's not going to make more people look at more shows. And I would say, having spent 13 years in Washington, that success in Washington is not the same as commercial success. There is a name, by the way, for the process by which incumbents succeed in the legal arena but don't succeed in creativity or innovation. The term is called regulatory capitalism, and it was created by William Kennard when he was Professor Clinton's chair of the Federal Communications Commission. He was giving a speech in Atlanta, Georgia, to those people who were involved in startups in internet telephony. There was a lot of opposition to them, not surprisingly, from incumbent telecommunications carriers who were petitioning the FCC for more regulations. Not of them, of course, but of the upstarts, right? And Mr. Kennard declined more regulation. And in doing so, in this speech, he sketched out a phenomenon that I think applies to copyright as well. Here's what he said. Regulation is too often used as a shield to protect the status quo from new competition, often in the form of smaller, hungrier competitors. All too often, companies work to change the regulations instead of working to change the market. I call this behavior regulatory capitalism. Regulatory capitalism is when companies invest in lawyers, lobbyists, and politicians instead of plants, people, and customer service. Rather than compete, incumbents get their cohorts in government to simply outlaw competitors' behavior, criminalize it. Regulatory capitalism always works best for companies that have the resources and know-how to play the game, and trust me, that's never the newcomers. Now, the focus of the speech is that law is not an answer to business problems, and that's why I have problems with these calls for stronger copyright, right? You hear it all the time. We need increased copyright protection. Now, it is true that there are a lot of people doing things they shouldn't do, and it's true that some of the things that these people do are unlawful under existing law and that harm the bottom line for people in the copyright industries, and those should be stopped. But it's also true that while copyright law can be used to stop some people from doing some things, the most important thing it can't do, which is it can't force people to buy things, right? You can't sue your consumers into buying stuff from you. And there's no enforcement agenda that's ever going to turn an unprofitable business into a profitable business. Now, there are people in Washington and other national capitals who are led to believe that if they're tough on infringers, why, everything's going to be right with the world, there'll be more jobs, there'll be more copyrighted works, and they're going to step in and do these sort of things. I certainly experienced that when I was in Washington. There was a member of Congress. At that time, he was in the House. He's now in the Senate. And he wanted to show that he was tough on crime because he was a Democrat. And Democrats have a weak spot for being tough on crime. So the way he showed he was tough on crime was to pass a number of bills. One of the bills was to make it a federal crime to move from New York to New Jersey to avoid a civil child support payment. Right? You cross state lines. That's a federal crime. Tough on crime. Another one was to make it a federal crime to mug somebody in an interstate highway bathroom. Okay, you're tough on crime, and we're all a lot safer now for it. You see the same thing in copyright law. We're going to increase the amount of penalties. We're going to increase the amount of time that people go to jail. And when members of Congress do that, I think they believe it's going to have a result. But it doesn't have a result. It doesn't have that result at all. So I don't think that stronger laws are going to help in the least. And I'll go even further about copyright, which is a field I love and I've devoted, at this point, 28 years to. So you don't spend 28 years and write as much as I've written for a subject that you don't believe in and don't like. Right? But if you see problems in a field that you love, I think you owe it an obligation to point out that there are difficulties with it. It's not a good thing to ignore it and think that things are fine. So here's another thing I don't think that copyright can do. I don't think that copyright creates economic value. That may be a heresy, so let me explain why. When I worked in the Copyright Office, I had a colleague called Louis Flax. And Louis was the Copyright Office's international specialist back in the days when the United States had very little to do with international copyright law. We weren't a member of the Berne Convention. And so Louis had this little niche specialty, and he was a very eccentric guy, and everyone left him alone. He was the only guy in the Library of Congress who could smoke cigars in his office. And he was also fascinated with Charlotte Rampling, so we had these photo books of her in his office too. He was a complex person, which is diplomatic language for saying he was a fascinating pain in the ass. But during the debates we had in 1988 about whether the United States should join the Berne Convention, the Berne Convention obligated the United States to give protection to the built three-dimensional design of architecture. We'd always protected architectural plans and drawings. We hadn't protected the built three-dimensional structure of it. I was very much in favor of doing this. I was enamored with architecture, and I still am. And so I must have been, prattling on rather effusively to Louis about the creativity of architects and how giving them copyright protection was a fantastic thing for them. So Louis took his, cheap, smelly cigar out of his mouth and pointed his finger at me and said, Patry, the problem with you is that you think copyright is fairy dust. Now, I vehemently denied the accusation, but, he was right. I did regard copyright as fairy dust. I did think that if you gave something copyright protection, it was magically imbued with economic value, and that therefore it was the duty of governments to go around and protect it, protect it from the looters of the world, in Ayn Rand's terminology. But, I found out that copyright actually isn't fairy dust. It doesn't give economic value at all. What gives things economic value is that consumers are willing to buy them. That's really it. So it's a profound error to think that if you have stronger copyright laws, you're going to have more economic value. And what's happened, I think, is that this call for stronger copyright laws has boomeranged like caffeine. Right? If you drink a lot of caffeine, what you find out is that the more you drink, the more addicted you become to it, and the less it does for you, the less good it does. Right? It's a very well-known physiological phenomenon, and I think it's true for people's reliance upon law as well. So for too many, I think relying on law has become their business plan. Right? It's a way to avoid innovating. It's a way to try and hold on to the status quo as it is. There's a former Harvard Business School professor, John Cow, who said that the United States has become the fat, complacent Detroit of nations. We are milking, it's good, it gets better. He says, we are milking aging cows on the verge of going dry. losing our collective purpose along with our fire, ambition, and determination to achieve. And I think that's actually what copyright law has become, right? It's become a way to milk aging cows that are on the verge of going dry. No, it just doesn't work. It's become sort of a tool by which people deceive themselves into thinking that they can avoid the sort of stagnation that's inherent in any product or service. The copyright somehow is going to eliminate product cycles. One of the books I read at the end of last year was a biography of Ruth Handler, who invented Barbie dolls and was one of the co-founders of Mattel. And Barbie is a product that's gone through a lot of changes. And what Ruth Handler said about it, I think, is really quite wonderful. She said, anybody can manage the upside of a product. It takes a real manager, however, to manage the downside of a product, right? To go on to something else and to figure out how to bring it back. And my fear about copyright is that it's being used to sort of eliminate or think that you can eliminate the end of natural product cycles. So what I think we need instead is managerial imagination rather than husbanding existing products and services in the hope that you can have controlled incremental growth. My father was what at least we call a schmata salesman. Now, he sold rags, but is actually a company in Dallas, Texas called Hager Slacks, founded by a Lebanese guy. And the founder's idea is that he wanted slow dimes, not fast nickels, right? His idea was controlled, incremental ways of doing things. And there are certain companies like this, too. When I worked for Congress, we wanted to abolish the compulsory license in Section 111, which gave cable companies the ability to retransmit over-the-air programming by paying a set fee rather than a market fee. And we were market-oriented persons, so we wanted to do away with it, right? We wanted to give copyright owners the ability to set market rates, to go out there and get whatever it is the market would pay for it. Surprisingly, there are a number of motion picture companies who didn't want it. They said, please, don't give us free market power. We like the controlled incremental environment. Our accountants know that they're going to get this much money each reporting period, and that's fine with us. Well, there are problems when you have that sort of approach. Now, let me contrast it with an example of a traditional company that I think is innovative, and I think it dovetails quite well with our last speaker. And that is Macmillan. So recently, Macmillan announced new software called Dynamic Books. What Dynamic Books will do will be to give college instructors the ability to edit digital versions of Macmillan's textbooks and to customize them for their own individual classes, right? So you're going to give college professors the ability to edit sentences, paragraphs, chapters, to add things, to provide links, graphs, all of it, by the way, without the permission of the original author or publisher, I assume because it's been cleared in the agreement with the author and the publisher originally. Now, students will be able to buy these dynamic ebooks, and I think dynamic is the right term for it, in bookstores through CourseSmart, which is a joint venture with 5 textbook publishers. They can download them onto laptops, they can download them onto iPhones, and hopefully onto iPads. And the price will be a lot cheaper than the traditional hard copy textbook. So if you take the textbook Psychology, for example, it has a list price of $134.29. The dynamic ebook, which you can do whatever you want with, is $48.76. So how does copyright law fit into this? Well, Macmillan expects that the dynamic books will replace used books, the resale of which is lawful under the copyright law. There's this thing called the first sale doctrine in Section 109 of the Copyright Act, which says if you have a lawful copy of something, You can give it to somebody else. You can sell it to a secondhand bookstore. It's why the Strand bookstore down on 14th Street exists and why there used to be used CD stores. But publishers don't benefit from that resale, of course. The student goes and buys the book and then sells it to a used bookstore who turns around and sells it to somebody else, and that's a revenue stream that's lost. But to try and capture that lost revenue stream, of course, what publishers have done, at least for textbooks, is to increase the original price of the book rather substantially. So what dynamic books will do will be semester and class specific. And that should actually eliminate the resale value for those, because if you weren't in that class for that semester, then it's really not going to be of great use for you. And Macmillan hopes that we will cut down on the used book market and also eliminate the prevalence of some pirated edition. So among the really cool things, I think, about dynamic books is that it takes a market solution, right? It says that consumers can add value to things, and if they add value to it, then they're going to be willing to buy it, and they're going to be willing to buy it for a particular purpose. They're rewriting things to serve their own needs. And I think that's a great solution. It's a much better solution than what some people have tried to do, which is to eliminate the first sale doctrine. Right? Say, oh no, we're not going to let people resell things, which is a crazy approach. This is a much better approach to say to people, okay, here's the book. I'm going to sell it to you at a fraction of what it was, and you do what you want with it and make it useful to you. So I think this is really a fantastic solution, and I hope that others follow it. You hear the idea that you can't compete with free. And I think that's the wrong question. The question isn't whether you can compete with free. The question is whether you're going to give consumers something that has value to them, and if it does, they'll buy it. And I think the dynamic books example shows how that can be done. So that's the conclusion of my speech, and I thank you all very much.